This program is brought to you by the James Wilson Institute on Natural Rights in the American Founding. If you'd like to learn more about the James Wilson Institute, please visit jameswilsoninstitute.org. We hope you enjoy the program. Hello, and welcome to the Anchoring Truths podcast. We are delighted to have on as our guest Giancarlo Canapera of the Heritage Foundation. Giancarlo, what is a nationwide injunction?
Well, nationwide injunction is a bit of a misnomer, actually. They're better called universal injunctions, or as I think Justice Gorsuch called them in one case, cosmic injunctions. And the reason is that geography is not what defines these things, and geography is not what could constrain them. They are universal because they apply to people who are not parties to the case. So let me take you back through a little bit of history, which comes from a great law review article by a professor formerly of Notre Dame, now I believe of Chicago, although I could be wrong about that, but named Samuel Bray. And he traced he's a great scholar of the court's historical equity powers. And he sort of woke up one morning in his telling and noticed that courts were granting these universal injunctions. And he thought, wait, hang on a second, where the heck did these come from? What's the intellectual foundation that was laid under them? What's their historical pedigree? And he found that the answers to all those questions were, they came up very recently. There's no intellectual argument for them. They have no historical pedigree. They just sort of emerged out of the ether. But historically, what courts granting remedies did, granting injunctions did, is they would, particularly against the government, they would say, you government have articulated an unconstitutional policy or passed an unconstitutional law or enforcing a law in an unconstitutional manner. You are enjoined, you, the agent who has been sued, are enjoined from enforcing that policy against the parties who sued you. And that's it. None of this striking down of laws with which is sort of how we traditionally talk about what courts do. That is totally a new creation. But in the 60s or so, and Sam Bray attributes this in part probably to some sloppiness in our language, we started thinking and speaking about courts striking down laws, even though that's not what they historically did. And so because we started talking that way, courts just sort of started doing it. And what they would do is they would say, the government now has done something unconstitutional, promulgated an unconstitutional law or regulation, or it's enforcing a law in an unconstitutional manner. You, the entire government, are enjoined from enforcing that law against anyone, anywhere, at any time, whether they're hearing this lawsuit or not. That is a universal injunction. So that's why the moniker nationwide is a bit of a misnomer, because it's not the geography that matters, it's the parties that really define whether the scope of a remedy, and therefore whether it's a problem, or the remedy has gotten too big or too broad.
So, what non-lawyers may think is curious about the discussion of these universal or cosmic or nationwide injunctions is, it seems like a lawsuit is between one person or one organization against the federal government. And yet there's all this concern about throwing sand into the gears and seizing up the actions of everybody in the entire country. What is it about this remedy that has such outsized impacts on parties who aren't even part of the lawsuit?
Yeah, let me approach the question from this way. There are, I forget what the exact number is. I want to say about 600 federal district court judges in the country. Is that right? That might be, it's not exactly accurate, but there are several hundred federal district court judges in the country. Imagine this: the president announces a policy, or Congress passes a law, and it's challenged in 599 of the courts. And 599 of the federal district courts say, this is perfectly constitutional, you can go ahead. And one judge says, no, this is unconstitutional. If that judge can issue a nationwide injunctions, all 599 of the other decisions don't make it. That judge gets the only say about the policy, and it's enjoined nationwide, universally, with respect to everyone, everywhere, always, unless and until that judge is reversed on appeal. So this creates a whole bunch of problems. Number one, it makes the one district judge who says no the most powerful district judge in the country. In fact, it makes that district court judge more powerful than any Supreme Court justice, none of whom can act without the majority of their peers. It also means that if that judge is wrong, which he may very well be if he's 1 out of 599, it doesn't matter. There's no mechanism by which he can be reversed, or that rather, there's only one mechanism by which that decision changes, and that's him getting reversed on appeal. The whole machinery of government has to stop and wait for that single judge to be challenged on appeal, for that case to go up. It also means that because that judge can enjoin the policy nationwide, every single no that a district court judge issues, or one, the one no that the Congress or the president gets, that's now an existential crisis for the policy, and it has to go with the utmost speed to the Supreme Court. That means a couple things. It means that you're not getting percolation in lower courts. You don't get to actually hear from all the judges, all lower court judges weighing in, debating amongst each other the way circuit courts do and lower court judges do. It means that the Supreme Court has to take the case, gets the case with only as much dialogue between justices as could be had before a judge said no, which often means very, very little. Which means that the justices are ultimately making decisions with very low information, very low exchange of ideas among the other lower court judges, and on an expedited basis. And as a bunch of the justices have said, that means their decision making is poor. And so when you finally do get a final decision from the Supreme Court, the decision is not going to have the sort of rigor, the attention, the carefulness that they expect and that we want.
So the usage of these injunctions has not been limited to one political party or the other. It's almost like a weapon that has had the effect of ratcheting up the stakes in our politics. What is it about the? Yeah, go ahead.
To some extent, although there is definitely a disparity in their use. Democratic judges use them much more frequently against Republican presidents than the opposite. There are a number of Republican judges who have taken a position against nationwide injunctions as a matter of constitutional law and history. There are, to my knowledge, no Democratic judges who have done the same. And when you look at the rate at which they are issued, it starts, there are a couple of them. There are some during George W. Bush's term, very few though, and then a few more during Obama. Trump 1.0, a ton of them. Biden, some, and then Trump 2.0. It's just madness.
Right, which is why the response by the Trump administration has been so strong to try and figure out whether or not the abuse of the remedy is tied to something other than the number of policy areas as well as legal fronts that these injunctions are being deployed towards. Because I think you and I would certainly agree that it wasn't for lack of ambition that the Biden administration was forging ahead in novel areas, as much, if not more so, than this administration.
Yeah, I think that's all correct.
Right. So you wrote a piece for our web journal, Anchoring Truths, which was titled "The Best Way to Fix Nationwide Injunctions." And that was responding to an ambitious proposal made in the pages of the Wall Street Journal by a law professor named Elizabeth Price Foley, who argued that the Supreme Court itself could eliminate nationwide injunctions by amending the Federal Rules of Civil Procedure, specifically Rule 65 of the Federal Rules of Civil Procedure. Why did you disagree, though, with Professor Foley's recommendation?
Yes. So uh, it's not that the Supreme Court can't abolish nationwide injunctions by amending the rules. It could, but I think the problem with the Supreme Court is not that it lacks a way to end nationwide injunctions, but that it seems to lack the will to do so. Uh, Amending the rules of civil procedure to get rid of nationwide injunctions would take probably 2 years at least. Requires all sorts of feedback from all sorts of institutional actors. The Judicial Conference, which leans pretty far left, and would probably not be interested in doing that when there's a Republican president. It just seems like a really convoluted way to do what the Supreme Court already can do, right? The Supreme Court can take a case and say, as Justice Kavanaugh and Justice Thomas and Justice Gorsuch have said, and that Justice Kagan has sort of hinted at in speeches, that nationwide injunctions are not lawful. If they're not constitutional, as I've argued, if they have no historical pedigree, as Sam Bray has argued, if they are contrary to existing case law, as I have argued, um, then the Supreme Court just takes a case and says this remedy is not permissible, and there you go. But the Supreme Court hasn't said that yet, which suggests to me it's not for the lack of a way, but the lack of a will. I wonder on that point. So the Chief Justice just gave a speech or a media appearance of some sort, in which he said the role of the judiciary is a co-equal branch of government, which is meant to strike down the acts of Congress and the acts of the president, which are excessive. I think was is more or less what he said.
Mm-hmm.
That that tells me a couple things about the chief, which are from the standpoint of nationwide injunctions worrisome. The very fact that he would casually use strike down to describe what courts do suggests either that he's already picked a side on the nationwide injunctions issue and that like courts do strike down acts of the other branches, which is not historically what they do, or that he just hasn't sort of read the relevant literature on nationwide injunctions and doesn't realize that that's a loaded term. Either way is not a good sign from his perspective. Um, and then, I don't know. I don't know where Justice Barrett is. Justice Kavanaugh seems to be against nationwide injunctions. Justices Gorsuch and Clarence Thomas are solidly against them. I cannot imagine that Justices Sotomayor and Jackson would strike down nationwide injunctions when a Republican president occupies the White House. Justice Kagan has made comments complaining about nationwide injunctions and complaining about the effects of nationwide injunctions, particularly that they force the Supreme Court to decide cases on an expedited basis with poor information. But I also wonder whether when there's a Republican president, she's going to have the courage of that conviction. So yeah, we'll see. We're counting votes right now. I wouldn't count higher than three.
Yeah, so Giancarlo, you're referring to the upcoming case this week in Trump versus Casa and some consolidated other cases in which the court will be specifically addressing the halting to one of President Trump's executive orders directing the rest of the federal apparatus to view birthright citizenship secured under the 14th Amendment as not an understanding of his administration. The interesting wrinkles of that we'll get to later in our episode, but I did want to focus on how you in your piece responding to Professor Foley made a very interesting observation that I think our listeners will catch on to quite quickly based on some of the other discussions we've had on this podcast. You wrote that to see the seriousness of the universal injunction problem, consider the case of Dred Scott v. Sanford and Abraham Lincoln's response to it. There, the Supreme Court wrongly held that Black people were not citizens, but it did not apply its holding to all laws that recognized Black people as citizens. But there was no nationwide injunction. Of course, in 1854 when Dred Scott first began as a lawsuit. Lincoln could only obey the decision with respect to Dred Scott himself, but refused to abide by its broken logic in similar cases. Lincoln continued to grant passports and patents to Black people when he was president, legal rights that only citizens could have. Nationwide injunctions foreclose such statesmanlike departmentalism. If courts had the power to issue nationwide injunctions, something unthinkable in 1857 when Dred Scott was decided, a single slavery supporting district judge could have enjoined the Missouri Compromise itself and the application of any laws and practices, like granting passports and patents to any Black people anywhere in America or its territories. I thought that just brought home how unique this remedy has become, or at least how it's been, morphed over the years. That what we think of as a key feature of the founders' Constitution, that each branch has an independent obligation to interpret the Constitution according to its own understanding, rather than basically just look to the Supreme Court, outsource all understanding of constitutionality to that one branch. You made that keen observation that this is in strong tension with the founders' design.
Yeah, yeah, that's exactly right. So it's why I find this is my biggest problem with Chief Justice Roberts. Put aside his penchant for politicking for the sake of avoiding looking like he's politicking. Um, but this is my big problem with Chief Justice Roberts, is he doesn't seem to have any conception of like the historical role of the judiciary in the regime. He is a judicial supremacist par excellence, and he takes this extraordinarily maximalist view of what judicial supremacy is, which is that not only is not the courts are not just the final word, uh, but they are the only word when it comes to constitutional questions. Um, Such that I don't have confidence that he doesn't. I don't have confidence that he could see a problem with nationwide injunctions. He may think that when there's a nationwide question and the executive or Congress is wrong, of course, courts get to just strike it down because that's what courts do. It's not what courts did, though.
So, on the question of how the court is going to approach, the questions in Trump versus Casa Inc., there's been plenty of speculation on whether or not the court is going to even touch the underlying merits or the question of whether or not the 14th Amendment does, in fact, secure birthright citizenship. And it was the subject or the focus of the briefs from the Office of Solicitor General that this case would be, or at least this case should be, all about universal or nationwide injunctions. What is your understanding of how the dynamics are going to be at play at the court with regard
Yeah,
to that merits versus non-merits question?
yeah. So the Solicitor General has done, or the acting Solicitor General, I guess, Sarah Harris, has done her absolute best to make this case just about the injunctions. What she's asking for, so she brought the case up to the Supreme Court, and what she has asked for is a partial stay of the nationwide injunction itself. Well, so what she wants basically, let me paraphrase. I don't quite remember the quote directly, but what she says is essentially, we want a partial stay of the nationwide remedy while the lower courts consider the merits. In other words, the lower courts ruled against us. We're not challenging their merits decision now. We're only challenging the scope of the nationwide injunction. So that is as clean as it could possibly be for the Supreme Court. The Chief Justice is a master of muddying clean issues. So if he doesn't want to take up that issue cleanly and he can get a majority together around that position, he may succeed in doing so. There are a variety of ways that he could reach the merits in one way or the other to some degree, and try to dodge the nationwide injunctions question. I know, for instance, Josh Blackman, who is a frequent blogger on this topic, blogs a little bit of all conspiracy, thinks that the Supreme Court will knock the administration on the merits somehow, and not touch the injunctions issue. And I'm not quite sure I see it. I mean, maybe I don't give the chief as much credit for being able to snake his way around issues as perhaps he deserves. But I think that they really have to take the nationwide injunctions issue here. I also think that they probably want to. Um, it is obviously becoming an immense problem for them. Although Kagan, for instance, has never said in an opinion that she doesn't like nationwide injunctions. She has done nothing but whine about their effects in public appearances for the last year and a half or so. So surely, there's maybe a vote to take this on that issue. You've definitely got Kavanaugh, Gorsuch, and Thomas, of course. I'd imagine Justice Alito is probably fairly skeptical of them. He's at least going to listen. I just think you can probably count at least four votes to make that the core issue. Um, so yeah, we'll see. I think they'll tackle the nationwide injunction question and not the merits at this stage.
Yeah, what benefit really would come from providing less of less of the clarity that seems to be sought by the majority of lower court judges who are not flying to this remedy at the drop of a hat. I think, I guess the question that I'm trying to get at is like, why are we letting, unfortunately, several dozen, but still that's the significant minority of federal judges essentially acting, in bad faith, because when the shoe wasn't on the other foot, they were sorry. When the shoe was on the other foot, they were more than happy to explore other remedies. Why are those other judges probably the silent audience that that are very much looking to guidance from the court on this one?
Yeah, well, I mean the reason that I guess you described as we are letting some of these judges grant these injunctions is because, well, ultimately you and we have no say in the matter. The judges invented this remedy for themselves. The Supreme Court has never weighed in on it. Um, so yeah, I mean, we're sort of overdue. They just at this point they just have to say yay or nay.
Mm-hmm.
Um, I'm hopeful that they say nay, but it would be great for them to say something.
Mm. Well, when you
I'll tell you one thing. If they don't say nay to this practice, or if Justice Kagan in particular isn't the one to say no to nationwide injunctions, I don't want to hear any more complaining from her in the press about how hard her job is these days. She was just complaining a couple weeks ago that oh, we don't have summers anymore because the shadow docket, the emergency docket is so busy. And like, you could stop this. You could do it. That's on you. Don't complain to me. I'm doing nothing here. This is on you.
Yeah, the difficulty perhaps with the question of thinking of this as only an issue that is for the court to decide is part and parcel, I think, of that faulty assumption of judicial supremacy. Some of the best proposals that I think you and I have heard have actually come out of the Congress on this. There are some quite novel legislative proposals that have proliferated from Senate Judiciary Committee Chuck Grassley in particular
Mhm.
to expedite Supreme Court review of lower courts that are seeking the universal or nationwide injunction remedy. There's also a proposal to create a special court to hear nationwide injunctions when these are being sought from the lower courts, as well as a proposal to expedite review of universal or nationwide injunctions by a three-judge panel composed of judges outside of the district where the universal or nationwide injunction originates. I mean, I think of these as, remember, the lower courts are all creations of Congress, and they can certainly, and they have in the past, they can certainly be subject to acts of Congress on jurisdiction, but as well as these resource saving methods. What do you think about some of these proposals?
I think I think that they're all, some of them are good, but I think they're all ultimately second best solutions to the best solution, which is for the judges to behave again the way that they were meant to behave when the founder set up the country. Anything which creates an expedited review process creates or doesn't cure one of the major problems with nationwide injunctions, which is that they force the courts to move much faster than they ought to, particularly the Supreme Court, without the benefit of all the dialogue that happens among lower courts. My concern about creating, say, a specialty universal injunctions court is that that just creates one centralized institution to be captured by whichever faction. But that worries me. At least this way you can sort of, this way, as soon as one judge issues the order, right, you're only going to capture one judge. So I don't know that it's particularly better. But I mean, ideally, what I really want to see, the nationwide injunctions problem is a problem of the courts not sort of constantly self-reflecting on their own authority and and just sort of without reflection, without question, aggrandizing their own authority over time, so that we sort of all woke up one day in about the 60s and discovered there was this new tool that courts were using, and nobody had ever theorized it, and nobody had ever defended it. And that it's a problem fundamentally of the failure of self-policing. And I think that the courts ought to police. And what that would look like is they go back to a more limited classical understanding of their role as enjoining enforcement as to parties. Now, let me give the best defense of nationwide, the most salient defense of nationwide injunctions that I hear. It's not the best one in
Sure.
the law, but it's the one that non-lawyers fixate on. And it is this, that like, if a policy is nationwide in its effect and it's unconstitutional, surely a judge has to enjoin it nationwide, because otherwise then a bunch of people just have to sue everywhere all the time. The
Yeah, we hear
argument,
we hear that from our friends in the conservative public interest community for sure.
anybody who makes their living suing the government loves the nationwide injunction precisely for this reason. The problem with this argument, though, is that it forces you to make a really serious concession, which I'm not willing to make, which is that is the role of judges, and that there are not costs associated with that, or that those costs are just not worth looking at. But the costs to that are actually enormous. It makes judges on par with the president and superior to the Supreme Court and superior to Congress. District court judges are the only officials in America, with the exception of the president, who can wield any sort of governmental power alone. But unlike the president, unlike Congress, they are not elected, they are not accountable. They can only be checked through the unaccountable, unelected judiciary. It's important that you have a branch of government that is there to check unconstitutional things done by the representative branches. But that power has to be really carefully guarded and really carefully used, because if you get it wrong, it's anti-democratic, it's destructive of majority governance, and there's really very few ways to fix it. So my sense is that you're going to get unconstitutional things done by every branch of government from time to time. But if you're going to err one way, it is better to err by denying judges the ability to strike down a policy wholesale across the whole country for everyone. Because if they get it wrong, that to me is worse than if the elected branches get it bad. And how you can see how this plays out through all sorts of examples through history. So consider, for instance, the famous Youngstown decision. This was, I forget which president it was. Was it Eisenhower? Who wanted to
I think that's right. It was 1952, or at least the case came. So maybe it was Truman at the end of his term,
Yeah,
but yeah.
yeah. But one of those two presidents essentially wanted to nationalize a bunch of steel mills to help with the Korean War effort. And several of the steel mills, but not all of them, and not a class, uh, filed suit, won an injunction against the government, not a nationwide injunction. The case went to the Supreme Court and they won. And it was, let's say it was five steel mills. That left all the rest of the steel mills in America, which technically were not covered by the injunction. The administration, had it wanted to, could have then gone and tried to nationalize those. It didn't. Why? Because the president is not an idiot. That president was something of a statesman, at least, whichever way, whether it was Eisenhower or Truman. And he realized, look, okay, I've got a decision. It applies to these people, but I can sort of see, okay, maybe I am wrong. I've got the humility, at least, to consider that I'm wrong. The Supreme Court has said this. If I go after these other people, they'll say it again with respect to them. There's a certain zone of statesmanship which is preserved when the Supreme Court and the lower courts don't just ice the government out of everything everywhere. And so that also is one of the things you lose with nationwide injunctions is you crowd out the ability of statesmen to be statesmanlike, and you turn every fight over a policy into an existential death struggle between the three branches of government.
Well,
Um,
I always thought that Chief Justice Vinson's dissent in Youngstown made more sense, but I feel like I'm a lonely voice on that one.
I don't actually at this point remember the merits arguments, but just from the standpoint of how the case shook out as illustrative of um, what happens when you don't issue a nationwide injunction, but you leave the president some room uh, to exercise prudential statesmanship.
Yeah, well, if I recall, that was Vinson's basic argument that the president and the Congress were in dialogue, and that the court need not have stepped in because they were basically hashing things out. It was high stakes. It was a matter of great national interest during wartime, um, but that these are things that courts typically don't intervene in. And
And that lies with the founders' understanding of the political branches. Like they expected that a lot of constitutional questions would be resolved through politics,
mhm.
through consensus building and negotiation. They didn't expect that the judges would be roving the country like policemen. Um, Precisely because, and they didn't want that, precisely because the judiciary gives no opportunities for representative self-government.
Yeah, so there are two more items that are going to be perhaps part of the discussion of this Trump versus Casa oral argument, and then some of the commentary afterward. The first one that I'm hoping you can help our listeners understand is discussing Rule 23 of the Federal Rules of Civil Procedure and the forming of a class of
Mhm,
litigants. This is
mhm.
this is a very very central part of any kind of litigation that seeks the universal injunction as a remedy that the lawyers for the plaintiffs have described a and have made an argument that passes muster to certify a class of litigants that are reasonably similar, so that indeed could represent a class of litigants that would then be compared to others who in the case in terms of like judicial efficiency not need to individually be bringing their cases. What role in the abuse of the universal injunction remedy does maybe Rule 23 have? And
Yeah.
do you think that is something that could be a very fine distinction that the justices try to draw out in oral argument?
So I think actually one of the perverse things about nationwide injunctions is that they render Rule 23 and class actions largely superfluous. What you'll see in a lot of these nationwide injunctions cases is that there is no class. You don't need to certify a class if you're just enjoining a policy against everyone everywhere. You've just created a universal class. Um, but class actions exist and they come out of British common law precisely to sort of deal with the tension which exists, which the criticism we just talked about sort of gets at, which is, well, sometimes there are a lot of people affected, right?
Mm-hmm.
And so class actions were created in part or grew out of the British common law in part to address that concern in a way which sort of tries to strike a balance. The idea being that, okay, judges are limited to the parties before them. And so you may create a class, your party is a class, right? It's all these people who are similarly situated, they have the same injury or similar injury, they're sufficient numerosity, right? And so that the whole class action exists to solve that particular problem and to respond preemptively, incidentally, to this critique about sometimes you need sort of universal relief. Well, yeah, that's why we have the class action. But nationwide injunctions are often given, well, sometimes they're very often given without any attention to class, period. But sometimes they're given precisely when a class action wouldn't be appropriate, precisely when you don't have people
Mm.
with a unified interest, a similar injury, sufficient numerosity. They're a sort of nationwide injunction, sort of a sloppy way of avoiding that whole set of questions, which can be difficult precisely because they're supposed to be difficult. Right? Because when judges start giving remedies to a whole bunch of people, you run into all sorts of risks that the class action balancing test seeks to minimize and cabin, seeks to strike a balance. But nationwide injunctions render Rule 23 largely superfluous, and so undermine that entire balancing framework that Rule 23 tries to get.
And the other item that may come up, though it's perhaps less likely, is how there are statutory hooks, for example, in the Administrative Procedures Act, that create the ability for litigants to seek a universal or nationwide injunction, and that because right, if you're suing a federal agency for regulatory relief, that regulatory relief is being sought against a regulation that's binding nationwide. Is it such that we are dealing in the Trump versus Casa case, though, with such a very clear constitutional right as opposed to a harm that's being done under the administrative state, that it might it might be rightfully considered separately in that context of the APA versus what we have before us very clearly in the 14th Amendment birthright citizenship space.
Yeah, so a couple things. Number one, let me just reserve the right at a future time to dissent from the claim that the APA grants universal vacatur. I'm actually not convinced about that. And I'll hopefully be publishing a law review article about that in the next coming year. I'm trying to get a journal to take it at the moment. But I'm not convinced about that. I think that when the APA says set aside, it may not mean strike down the way we think about, but put that aside. Um, I don't know the underlying complaint in this case, whether it tried APA, but the APA would be a weird fit here because, as I understand it, the case is attacking the executive order itself, and the APA explicitly does not apply to the president. So that's one thing. But where this does sort of raise difficulty, especially for the judges who come from the DC circuit, which includes Kavanaugh, Roberts,
Jackson.
Kagan didn't serve on the court, but she litigated there. They all understand the APA set aside language as meaning strike down a rule, just strike it down. We as judges can just basically erase it from the statute books. That's how they understand it. So if that's how you understand the APA, you might sort of default to thinking that's how judicial review of statutes goes too, right, under the Constitution. Maybe we strike down regs, we strike down laws. Why not? So that's where I think that may be playing in the background. I'm a little bit worried about that. So yeah, but that being said, I don't know. I don't think that the APA comes up directly during this case.
Well, we're going to be watching very closely this Thursday as the court hears oral argument in Trump versus Casa. But Giancarlo, this has been just a really, really fun discussion of what I think is the hottest legal issue before us today. Where can our listeners follow your work? Can you give them a little taste of what else you do? I know you probably don't wake up every morning and think about universal injunctions from sun up to sundown. Can you give our listeners a little taste of what else you work on at the Heritage Foundation?
Yes, I work on a bunch of different issues. I do a lot on equal protection and race and sort of what you might call the philosophy of equal treatment under law, administrative law, which means nationwide injunctions, um, and a bit of sort of constitutional pitch hitting on various separation of powers issues. I write law review articles. Those are I try to put them all on SSRN. I think I'm a little behind. And then short form pieces are either on heritage.com or .org, and then on my social media accounts, X and LinkedIn. I try to post everything there too.
Wonderful, wonderful. Well, we'll make sure to include links to some of your recent writings, particularly on the universal injunction issue, as well as some of your other. You just testified in front of Congress, actually. What is it? Last week or 2 weeks ago?
Last week.
Great, you're a man. You're a man in demand. We may have to include the video of that one. So again, we've been joined by Giancarlo Canaparo of the Heritage Foundation. Thank you so much. This was a lot of fun, and we look forward
It's
to
always a pleasure.
yeah, we look forward to having you on again soon.
This program has been brought to you by the James Wilson Institute on Natural Rights in the American Founding. If you'd like to learn more about the James Wilson Institute, please visit jameswilsoninstitute.org. Thanks for listening.